Each person that's in the construction industry has a responsibility and a due diligence to do their homework. There's also a lot of companies that go bust on purpose and don't pay their suppliers or subcontractors. Part of taking the con out of construction is there is a lot of con men and cowboys out there. When our house is being built, we're excited about it. I had a meeting with the contractor. Listen, I know what goes on in people's houses. I know what you do in construction. Just don't do it in my house. Don't cut corners in my house because my name will haunt you. And they cut corners.
Welcome to Taking the Con Out of Construction, the straight-talking show that's changing the industry, one episode at a time. Small mistakes can cost big money, and even more in time. But a small investment in listening to this episode could help you avoid disputes, delays, and costly pitfalls, while giving you the know-how to stop problems before they start. Let's turn complexity into clarity and take the con out of construction.
Welcome back to Taking the Con Out of Construction. With me, as always, is Michelle Carr, an expert in navigating the complex world of building and contracts, and someone who believes knowledge is the best protection. In this episode, we're going to break down the Construction Act in simple terms, what it is, why it matters, and how it can protect people managing projects. Welcome back, Michelle. I know our listeners are going to get a lot out of this episode.
I hope so. The Construction Act, official title, is the Housing and Regeneration Act of 1996. It's a big law. I'm pretty sure it covers things about government expenditure, about regeneration, how it's going to be regeneration of the country in general. There's a lot of detailed bits and pieces in it. And I'm pretty sure there's regulations in there on procurement and government contracts and things like that, which I think have been amended now. The Construction Act and the relevance of most people that I deal with, my work and my client base as such, and probably people listening to this, is about the introduction of ADR, which is Alternative Dispute Resolution, and the JCT contract. Prior to 1996, where I was still at school, so I didn't know that much about the ins and outs of contractual stuff and law and things like that. I mean, as I said before, I was working in my dad's company then, on and off, but I didn't really know, obviously, what I know now. But prior to that, what used to happen was main contractors, clients, whoever was paying the bill, didn't pay the bill, and the smaller companies couldn't afford to go to court. So their only recourse at the time was legality, so going to court. So it would either be going to court the standard way you would, either through small claims court, which takes forever, larger courts, arbitration can take years. And basically what would happen is the contractor or the subcontractor or whoever it was that owed the money didn't bother because they couldn't afford to, because by the end of the time they got the judgment, the solicitor's fees would have way outweighed what they was being owed. So people just got away with it. Contractors went bust and it was awful. Bearing in mind, this is a different age before we had the whole digital age that we're in now. So what happened was one of the biggest changes and the biggest thing that came in with the Act was the chance to adjudicate. Now, adjudication is classed as rough justice. It's changed quite a lot more recently, but basically it's a process where if something's wrong and a dispute crystallizes, and when a dispute crystallizes means that there's a problem and you've tried to resolve it and you haven't. And most of the time it's over payment, but it could be over time, to be over a delay. It's an issue with the construction project. And there's a process you have to follow. So you say to them, you've tried to get the money, you've tried to do the dispute resolution, you haven't been paid. Now, if you haven't been paid, you can say, unless we get paid in 7 days, we're pulling your site, or we're doing this, and we're going to take further action, a pre-action protocol letter, we're going to adjudicate. And within the contract, it will state, if you want to adjudicate, how that works. There could be an adjudicator listed in the contract. It's normally the RICS or the CIARB, which is the Chartered Institute of Arbitrators, which is where I train. I'm an associate member of the CIARB. That's where adjudicators get trained and qualified. And there's a number of courses that they do, and arbitrators. So you present your case to the adjudicator, whatever it may be. And you really need proper advice on that. I'm an associate member of the CIARB and I don't know, right? There are people that are specialised in doing that. I can do the pre-action stuff and I can prepare for it. But the actual adjudications themselves, I don't like doing it. So you go to a professional, they do their case. They send that to the adjudicator. The adjudicator will send it to the client, and you've then got 7 to 14 days. So you start the adjudication process, you've then got 7 days to issue your information to the adjudicator. The adjudicator then reviews that, sends it to the client, the person you're wanting the money for. They've got 14 days to respond. The adjudicator's then got 14 days to read both the information. Now, this is where it gets difficult. There could be a truckload of information for this adjudicator to go through. They've got 14 days. Now, unless they've got valid reason, and there's a criteria for that reason for that to be extended, they have to make that day. So you've got a 28-day process from when you've raised a dispute, you've got a judgment. And that judgment, whatever the adjudicator says, that is court enforceable. So then if you've got an adjudication and they still don't pay, you can go to the courts, apply to the courts, an injunction, county court judgment, whatever it may be. They very rarely go against that. Now, adjudication has changed in recent years, and they've changed sort of regulations and how it works, but we'll talk about that in more detail. And another point, if you've got an adjudication now and the next episode isn't out, then obviously feel free to contact me directly, because time is of the essence. But it's rough justice. So you would get a payment. So if a client hasn't paid you for no other reason except they just haven't paid you, they don't feel like it, whatever, there's no valid reason, they haven't issued you a payless notice, there's not a valid reason for not paying you, theoretically you can get paid within 28 days is the plan. So that means that subcontractors can stand up to main contractors, or main contractors stand up to clients. They haven't got the whole threat of, well, take me to court, no, I'll adjudicate you. And that takes a month. And ultimately, even though some companies can't last that long, you've got something in a month or 6 weeks. But then again, you have to be very careful when you're doing adjudications. Again, we'll talk about this in more details, making sure that you terminate right and give the adjudicator the right powers. But it's not a fail-safe. But ultimately, it was to empower subcontractors. That was the purpose of that element of the JCT contract. So as part of the JCT standard process, obviously you've got a contract. It's mainly the payment terms, think what to do if there's a delay, what an extension time, what information you need to do. So in every JCT contract, there will be a process of payment, and it talks about due dates and before the due date and then the full payment date. And what most people don't understand is when you do an application for payment, you're supposed to do an application of payment for what would be due to you on the due date. Most people do this wrong, but we'll talk about this in another episode. The reason they have the 14 days is they can then check and make sure that's been done, and they've got an opportunity to do a pay less notice to say, well, actually, you were supposed to complete that work, but your guy went off sick, so you didn't actually do it. It's only 70%, so I'm going to pay 70%. That's like the idea of it. And then there's rules and variations. If you don't deliver on time, there's rules on extension of time. There's rules on how you deal with a change, on procedures, on project management, on procedures, on design changes, and obviously depending on the contract, whether it's design and build or whether it's contractors design portion or it's just standard or intermediate or homeowners, whatever it is, the process on design changes and information flow and stuff is all in there. Fluctuations, how things are priced, like there's a whole guide, and you can tick different boxes and basically what the rules are and how the contract's being done. And as it's a standard contract, it's now getting amended to ridiculous measures, and it's beyond even being recognised as a JCT contract anymore. But ultimately it had like a standard set of terms that people could rely on and get to use and understand to make the construction process work better. That was the idea around it.
Yeah.
And I think it's done that to some extent. But the problem is so many contractors and subcontractors especially just don't understand it. And even though it's in their benefit and they know that adjudication is an option, they don't get it. They don't get, for example, the fact that if they haven't been paid, they can send a 7-day letter. If you don't pay me in 7 days, I'm off site. And you can take your guys off site. They also don't know that most standard clauses, again, unless they're amended out, is if you have taken your guys off site, you're entitled to payment to reset up your site. There's other things in there of how to do if there's a variation or information flow, who's responsible for what and when, terminology descriptions to make sure that you've got that terminology right. And sometimes you need to look at that in contracts. Again, we'll talk about that in contracts. But these are the sort of things that happen and what the Act is there for. If they don't pay on time, you can charge interest. There's lots of different things that you can do. And there's mechanisms within the contract that are part of the Construction Act that allow you to do these things. To some extent, educates you how to administer a contract, which most people don't know. So an administrator of the contract is basically working within the terms and the constraints of the contract. So if this happens, do this. If that happens, do that. So that's contract administration to some extent, sending instructions like how to send an instruction, what information is required as part of the instruction, what to do to receive an instruction. And like, for example, variations, people always price variations wrong. We're going into this in more detail, but you're entitled to your QS's time, your manager's time, your secretary's time, whatever. And some variations have an extension of time associated with them, but how you deal with that, how you apply for an extension of time, all these things are detailed in the JCT contract. And it gave sort of like a basis. I don't know where the idea came from. I've no idea. I was only, 15 or whatever when it came out. But the way that it sort of presented and come into these specific terms, it gave everyone a base plate to put people on a bit more of an even feel. I've given you my theories on some of the issues with the construction industry, and it's a lot of it is mindset, but not everybody has gone into the construction industry who isn't academic. Some of them are academic and have thought, well, hold on a second, I've seen my dad doing this, that, and the other, but I can make a few more quid doing it this way. They've chosen to go into a trade because their dad or their uncle, or their brother, their sister, whatever, or they know someone that's good at something, but actually they need to be managed and they can make more money, or whatever. People come into the industry for different reasons, but not everyone is necessarily going to understand how to write a contract. And ultimately, back in the day, when they first came out, I had hated them. Because when I was working for my dad, everything was hard copy and everybody needed a copy. So I'd sit there and have to print out 6, 7, 8 copies of a contract. And it was handwritten too. So you'd come with these books and they're all different colours. So the yellow book, JCT with yellow. And then the little, I don't even know what it was actually. I think it was a picture of a building or something with different colours depending on what contract it was. So then you'd have the main contracts and you could have 3 different parties. You could have funders, you could have QSs, whatever. Everyone had to have a copy of the handwritten contract. So I'd end up having to write this contract out. And I'm dyslexic, so that's not great. Write the contract out, and then I'd get to the point and I'd be so nervous about it. And then guaranteed I'd have to get a spare. The last one, I'd get it wrong the whole time. And everyone had to sign every version because you couldn't, it was a booklet, you couldn't copy it. And then there had to be a copy of every drawing. I mean, these things would be like this big and I'd have to do like 8 of them. And then when you're doing the subcontracts, you'd have to do them again. And then normally there was only 2, but you then have to do the whole thing. And we'd literally have an office full of contracts. It was mad. But that's how it was done back then. And obviously it's now digital, but all the terms were there. You just had to fill in the blanks or cross it out or tick it. And you didn't have hundreds of amendments then, but it was a physical contract that you had and everyone kind of knew what contract did what and what the terms were. Obviously then, as I said, they started amending it and that's when it just got chaotic, but that's a whole other conversation. But that's how it was. The other thing is with the Construction Act is you are covered by the Construction Act whether you've got a contract or not. The only people that aren't covered by it, which people don't know, is if you're having work done in your own house. Which I kind of get to some extent, but they're probably the people that are exposed the most.
Yeah.
So I always recommend for people, if they're doing work on their home, they're not included in this Construction Act, they're exempt and they need to have a contract. I didn't find that out until I was working on somebody's property and they screwed us. And then realised that I thought we can be protected by the Act and we're not. It's specifically excluded. So if I'm working for you and you're having an extension on your own home or building a house for you that you're going to live in, then none of the terms of the Act apply. So you have to make sure you've got a contract, which is why I sort of bark on about contracts all the time and make sure that even if you don't want to employ a QS or somebody and a professional project manager, whatever, you don't want to employ a professional to do your project, make sure you get a contract from the JCT, buy it, download it, get one. Because otherwise you're not protected and you've got no recourse except litigation. So you can't go to adjudication, you can't go to mediation, can't do any form of dispute resolution. Your only recourse is litigation, and that's expensive and takes years.
From your perspective, Michelle, what are the most important parts that people should understand?
I suppose it depends on whether they've got a contract or not. For the smaller companies and the smaller projects that haven't used the contract, understanding how you are protected by the Construction Act anyway. If you choose not to have contracts and you're a smaller company or you're doing house flips or whatever it is and you don't want to do a contract because you don't want to have a bad contract, if you are doing house flips on your property but you're not going to live in it, you need to understand what you're liable for, because your contractor or whoever's doing the work for you will be able to go against you with the Construction Act because it protects them as much as it protects you. So that's a key thing about the Construction Act. But although we talk about the Construction Act, the main thing for the Construction Act is the contract, which obviously we're going to go into more detail. Ultimately, there are things there that protect people from payment. You've also got, after that, the Late Payments Act. So if people aren't paying you on time, you're entitled to interest if people don't pay you on time. There's other acts to follow, but that's a key thing. I mean, there's other things in the Act about procurement. So I'm going to say this on a general basis, is not something I've got a lot of experience in. I have worked with like the MOD before, but the way procurement can be seen in different ways. So you've got the procurement route is how you're going to go into a bigger project. For example, if someone's building a hospital and it's a multi-million-pound project for the government, a lot of the time it'll be a joint venture contract, which is different from a JCT. So a JCT is a Joint Contract Tribunal, which is based on the payment and all the other bits we've already mentioned within the Act or within the JCT contract. But it also talks about procurement as if to say, if you're going to work for a government, this is a process, this is how it needs to go, payment terms and how it goes out to tender. There's also within the Construction Act a tender process. So legally how the process works. A tender is when somebody has got an item of work to be done, and it could be an extension, it could be building 700 houses. There's a tender process. And you have a one-stage tender, two-stage tender. There's a number of different processes which are covered by the Act. Most people will understand a one or two-stage tender process. And what that means is someone has a project. Normally it's carried out by a PQS or a QS of some sort. They will find a scope of works or a schedule of works. You'll have a tender pack. This is also covered by the Construction Act. So you'll have the tender pack, it'll have the drawings in it, all the different drawings. It will have the client's requirements. It will have the contract in it. It will have specifications in it. It will have all sorts of different information. And you send that tender pack out. Now, the client will send it out to main contractors, and depending on the size of the project, it differs. The main contractor will send it out to subcontractors and sub and sub and sub. And people do prices. And the tender process is sometimes they'll send out part of the information, depends on the design stage. So the REBA, which is the Royal Institute of British Architects, have 9 stages. And depending on that stage is dependent on the level of detail and design that they've gone through. So it might only be a 2 or 3. So therefore they'll send it out to, could be 10 contractors, could be 5, whatever. Send it out. Now, when you send things out to tender, rarely does everybody reply and send it back. So it all depends on their workload. They'll have a look at the information, whether it's their type of work they want to do it. Some people will just price it because they want to stay on the tender list, but they've got no intention of doing it. There's various different ways. But the tender process, what's supposed to happen, it doesn't always happen, to have official tender, is everyone gets the same information.
Yeah.
What should happen is if one of the contractors asks some questions throughout the tender process, when you answer that question, you're supposed to be an addendum because it's about fairness. So if one contractor asks a few questions and you clarify, you are then supposed to send a tender addendum out that clarifies and gives that question, that answer to everyone to create fairness. That tender has to be sent back on a certain time and day. And back in the day when it was all handwritten, you weren't allowed to open them and they had to be sealed. And there was this whole process that needed to be documented of them all being opened at the same time. And that still happens in big government contracts and big contracts. That still happens. You have a PQS and it's very, very strict on the fact of when they can open it and how it's dealt with, especially government contracts. You have to stipulate by these rules. I've worked for PQSs and it's a sackable offence if you don't do it.
Yeah.
So it's about making sure everyone's got the right information and then how you process that information. And then you'll go back and there'll be queries. So for example, if you're doing a tender analysis, I'm not sure if this is actually in the Act or not, but this is a process anyways, we're talking about it. You're doing the Construction Act, you've got all the different prices. Now, they never ever fill out the goddamn document you send. Like part of the Act is you have to do this declaration, you have to sign it and you have to say it's all sort of official. There's an official way of doing it. It's all part of the Act. So they'll send the information and then you've got to try and get everyone's different form because most of the time they've got a piece of software that they put all the information in, it spits something out and they'll just send that. And you've got to try and get that document, or it's a bill of quants or whatever. You've got to get that document into your document and somehow compare the two. Let's say you've sent it to 10 people, you might have 5 companies that have priced it back. So then if you're sending queries, you have to send queries to everyone. There's a lot of it is to do with fairness. So 5 people have priced an item and 3 of them have come back at 10 grand. One of them's come back at 2 grand. The other one's come up with 25 grand. You then have to get each one of them to clarify that point, that 5 grand, and they know for well it's 25 grand, but they've put in 5 to win the work. These are things that you have to sort of look out for. The one that's 2 probably hasn't got it, but you have to make sure everything's equal. And then what happens is after you've done that analysis and then say, for example, someone hasn't priced something or someone's put provisional sum in, which means it's an idea, but they're not finalised it, but someone else has priced it. You have to do all this in the report. And then if someone hasn't priced something, then you just put a mean of what the other prices are. Then you get to a bottom figure. The bottom figure is never the same as what they look at the beginning. So you could have, let's say from 5 contractors, you'll then look and you'll probably take 3 to the next stage. And then it tells you about the process on how you do the next stage and what you need to do, and contractor interviews and how you carry out a contractor interview. Because when you get to the next stage, and then one of you is going to get the job and you let the other people go, and how you have to notify them is part of the act and all these other sort of official things. But if you're employing someone, a professional, they'll do all this for you and they'll understand that. But you definitely need to ask these questions. If you want to get into the industry, these are kind of things you need to be aware of and to know about. But also, some people doing the tenders don't necessarily understand how the tender process works. So I also train people on how to present their tenders. It's also about competition and fairness. One of the big mistakes a lot of contractors do is that they'll send their tender in and they'll add all the bits and pieces that they think should be done. They outprice themselves in the market. And I always say, put it below the line. Like, I respect you're doing it and you should do it because it shows your level of expertise and your commitment to the project. But just from face value, because all anyone looks at is at the price, right? How many times you did a quote or something and you're like, duh, you look at the bottom, and depending on what that number is whether or not you go back and reread everything or whether you bother wasting your time. You've got to do your best thing. You're selling yourself. You're trying to win a project. And if you've got cost savings, don't put them in at the top, because nobody knows you're doing a cost saving. Price it as it is, because then you're going to look different. It doesn't always work as you think it is. And you should never go with the cheapest price, by the way. I always put, right, I've priced what you've asked me to price. And then at the bottom, I'm going to say, there are these cost options if you do this, value engineering, and there are these things that we also think are necessary that's been missed out, because that's also always good. And I think that's a good way of working. But yeah, the construction industry is huge. So there's stuff about rail, there's stuff about infrastructure, there's stuff about water, gas, those kind of things I don't know anything about, because most of my experience is high-end resi, commercial, offices, fit out, that kind of thing, new build, modular, quite extensive, but there's a lot that I haven't done. So obviously the act is massive because it's an entire act. It's not just a simple piece of legislation. So it does incorporate a lot, and it is a bit scary. I mean, I haven't gone into all the detail on it since 2004 when I was at university, but there's a lot in it that people should understand and should know about. And one of the reasons I wanted to talk about it is because for people to understand, when I say to you, you do realise that the main reason for the Construction Act is to support people like you. And some of my clients were working in the industry back before the Construction Act, and it has definitely made a difference. There's no two ways about it. But whether it's made the difference it was intended to is a different story, because if you don't understand it, and as I said before, I've got a H&D in law and I struggle to read acts, but ultimately I've learned how to read law and I struggle. So I don't expect anyone else that hasn't read law to be able to understand it. It's complicated, but actually it is there on people's side, and it's there as a defence mechanism. And it's quite a good act, to be fair. Obviously, as I said, I don't know all of it, but the fact that the JCT's come out of it, even though that's still complicated in itself. So one of the things, we are going to be talking about that, because if you aren't following the law and your contract and the terminology, you're not issuing pay less notices is the biggest thing. If you're not issuing pay less notices, you will get adjudicated, and it doesn't matter. So if I'm working for you, and let's say I'm an electrician, and my contract value with you is 100,000, if I put an application for payment in for 80,000 on week 1, I'm being facetious, obviously, but if I put an application in for payment in on week 1 for £80,000, and I've done 1 day's work, if you don't issue me a pay less notice by the due date, on that day that payment is supposed to come in, if you don't hit it, theoretically within 2 weeks, I can have you in adjudication. And just because you haven't sent that pay less notice, I will win. And you'll have to pay me that 80,000, whatever I claim for, plus interest and all the rest of it. As always, people find loopholes, don't they? I don't think it's been quite as extreme as that, but people have been using the Construction Act. But then also, contractors are absolutely pissed off and had enough of not being paid on time. But they're generally good people, most contractors, and they work hard. And I always say to them, look, the Act is there to protect you, but you have to do what you're supposed to do. You have to deliver.
Yeah.
So I don't care whether your cat's sick or someone's got run over or your whole team went on a bend and they didn't turn up on Monday morning. That's not my problem. That's your problem. So I had some work done on my house and the contractor took ages. It was supposed to take 6 months. It took 9 months. He was supposed to spend 100 grand. It was 150, whatever. And variations of the like. And the homeowner will blame the contractor. And I will say, well, did you make any changes? No. but you didn't change a finish, not a door, light fitting, nothing. Oh, yeah. We changed this, we changed that, we changed something else. Okay. Right. Let me explain how it works. If you are going shopping, people always understand this because everyone shops. Even if you're single, everyone has to shop, right? We all have to eat.
Yeah.
If you are popping into Sainsbury's, Tesco's, whatever, you know, like the little convenient ones, the tiny ones on your way home, you're popping in to get a few bits for dinner. You pop in. What most people don't realise, it's more expensive in those shops. They inflate the price. No one necessarily pays attention to it because they're in a rush and they're desperate, they need it for dinner. So one, these things are more expensive. Two, you'll be in and out. You're picking up a bit of dinner. You might be spending 10, 15, 20 quid. You're running in about half an hour. You're spending X amount of money extra for dinner or food for a couple of days, or you've forgotten that kids need packed lunch tomorrow. If you go and do your monthly shop, or even a full weekly shop, let's say, you might go somewhere else. You'll pick up some bargain. You'll pay a bit more time, but you also spend a lot more money. You might be spending £100 depending on your family needs. And then you will take, say, 40 minutes, an hour. So that's a lot more money. It takes a lot more time. That's costing more money to do with what you're building. Why do you not expect that more money to have a time element to it? Because it's more work.
Yeah.
You do realise they planned the building and the whole programme from the information you gave them at the start. So when halfway through you change your mind, that means some of this stuff that's already been done has got to be changed. Well, they didn't tell me that. Did you ask them? No, but they should have told me that. You should have asked them. Communication is a two-way street. It's your project, it's your responsibility. You didn't understand what you were instructing, you should have found out before you instructed it. Or employed a professional. Now, as a main contractor, I'm different because I understand how complicated, and I don't want to get in an argument and not get paid and have to fight for my money. So I make sure when someone's saying something, I want to do this, I'm like, well, you can, but it's going to cost you this and the other. Or I will say, hey, we're putting all your wiring in for your electric, so let's have a conversation. This is where it's going. This is where your door's opening. This is where your light switch is going to be. Oh, no. My door can't open that way. I've got a bit of furniture going that way. Okay, fine. Door can open this way. Let's change the electric sockets to over here. Because if you change it when it is that first fix and the walls aren't up and it's not been plastered, there's no decoration, it might not cost anything. It's just going like this. But those walls have been plastered and decorated. That's going to take you a week and £1,000 to move it from one side of the door to the other. These are the kind of things that I deal with. But again, back to the Construction Act. You're not covered by this, by the way, if you're doing in your home. I just need to remind you of that. But these are the kind of things that it sort of got people doing and understanding where you should go with it and other bits and pieces. So it's very extensive. It's scary, but generally you need to ask a professional and find out what it is, but always get a contract anyway, and then you know where you stand, because that is the point of it. So you are covered if you're working in a business capacity, so business to business, or it's not your home, you're automatically covered by the Contraction Act. So people can't rip you off as much and just not pay you, but you also have to stand your ground. As long as you're doing what you're supposed to be doing, delivering what you're supposed to be delivering, and protecting yourself, putting in the right notices, covering your backside if there is a delay, why the delay has been caused, what reason it's for. And if it's your fault, then you're going to have to pay the price for it. So when it comes to extensions of times, if you haven't delivered what you're supposed to have delivered and you've delayed the project, then you will get LADs, which is liquidated ascertained damages. So if there's the consequence of your delay, so if it's a house or a restaurant or a hotel, by you not delivering on the time that you're supposed to deliver, there is a consequence and there would be a financial loss to your employer, the client. But obviously, if a client's the one that's caused the problem, the reason for the delay, then you should be paid for the additional time. But if you've caused the delay and they're losing the use of that asset, they can't open the building, they're losing financially. So another part of the Act is they need to be compensated for it, which is what LADs are. So because LADs can be high, they have to be reasonable. Some people, you have to keep an eye out. But again, we go over this in contracts in more detail. Ridiculous LADs. So, for example, somebody's building an extension and it's just your loss of time. You can't claim £1 million LADs a week if they're delayed. But if you're building like the extension of the Excel Centre and it's so delayed that they miss out on £1 million worth of revenue per day because they can't open it up for an event that they've booked in, then yeah, you will lose that £1 million a day for every time it's delayed. So the LADs have to be reasonable and you have to substantiate them. Sometimes it's difficult to put a monetary value on something like the extension of your home, but whatever, it has to be reasonable. And by reasonable, they thought it in court, so you can justify why you've come to that figure. But that's another thing that people should be aware of. The act is both sides. So if a contractor or a subcontractor isn't doing what they're supposed to be doing, they haven't delivered on time, they haven't delivered what the employee requirements are, they haven't done things safely, they haven't got the right approvals, they haven't done things in according with regulations, they haven't done what they're supposed to do and what's written on the tin, they're not entitled to payment, and actually the client can sue back. So there is that level of protection, because you do get, like, don't get me wrong, I'm talking to you about scenarios where we're talking about decent contractors and decent clients. We've mentioned the fact that some clients aren't necessarily ethical, but also there is the part of taking the con out of construction is there is a lot of conmins and cowboys out there. A lot of them.
Yep.
The opposite scenario of what I was explaining about the person having their house done in the shopping scenario, you've also got, for every one of those stories, you've got a contractor going, yeah, it's a nightmare client, they didn't pay, there was a nightmare, they did this, they did that. Did you deliver? What? But did you deliver on time? Well, no, but you know what it's like, and I couldn't get the this, and the scaffolder never came out, they went on a bender, they did this, and they did that, and this didn't happen, that didn't happen. Is that the client's fault? Or did you not manage your team properly? The idea of the act obviously is to protect both parties, but ultimately both parties are often at fault. So when I'm talking about how it's protecting you, you have to be doing what you're supposed to be doing, your end of the bargain. So if you haven't delivered on time and on budget for no reason other than the fact that you haven't delivered, then you don't deserve to be paid in full. I'm not saying not at all, but you can't expect, when you've told somebody it's going to take 6 months and they haven't changed anything major, they haven't really withheld anything, it's just you didn't get your arse in gear, or you weren't hard enough on your subbies, or you didn't get the right subbies, or you knew full well that in the program that one of the guys was getting married, and then not only would they all be away for the wedding and on benders, and they'd also all be away for the stag weekend on benders. You should know that as part of your management. You should have put a contingency in. And contingency is another point, because that's always something you should have in a contract, but you should allow for a program of works, and you should know what you're doing, and you should have accounted for anything and put risk in it. For example, like, everybody knows in the industry that you want anything from Italy or most of Europe in August, you need to put an order in May or June, because the whole industry shuts down. You're just not going to get anything. And then by the time they start up again, if you've placed an order on the 1st of August, guaranteed you ain't getting that until December. That's the way the industry works. The client isn't aware of that. That's not their fault. That's yours, because you're the expert and you should have known that. You're being paid to be a professional. You're being paid for your qualifications and expertise. And if you're not using those, and you're going to blame the client for not knowing what they shouldn't know, because you're supposed to know it, because you're the one that they employed and you're being employed for that level of expertise, then that's not on them, that's on you. So it swings and roundabouts, and in most situations I can see both sides of the point, but ultimately that's why contracts are important, which is why contracts are going to be the next thing that we discuss.
It was interesting when you mentioned loopholes. In your experience, is there anywhere where the Construction Act falls short?
Yeah, there are things where the Construction Act falls short. So I think the Act is written on the understanding that everybody's decent human beings, are all going to do what they're going to do. And I heard on the grapevine something's coming with Companies House about it, but it's the amount of contractors that shut up shop and open up a new business and just go bust. There are a lot of companies that go bust that shouldn't do, and it's really unfair and it's unreasonable. There's also a lot of companies that go bust on purpose and don't pay their suppliers or self-contractors. I do think there needs to be something tighter on that. I do also think that it's unfair that some of the big companies get away with things that they shouldn't, and I think there should be punishment for repeated, because I can only do what I can do, but each contractor and each person that's in the construction industry has a responsibility and a due diligence to do their homework, to find out where they stand, to be educated. If they're not educated themselves, they should employ someone that is, and everyone has that opportunity. But there are people that are greedy out there, and in today's age, I don't think it's difficult to prove whether they are, whether they aren't. And I think everyone should have the information to prove or disprove a statement. But I do think there should be penalties for companies that consistently, for example, cladding issues. So since Grenfell happened, which was awful, I don't think I'll ever forget seeing that building, and seeing it in person was chilling. It's bad enough seeing a picture of it, but physically standing there was chilling, and it has changed the industry. There's people I know that do a podcast about cladding, and there's been a lot about cladding, and there's a lot of buildings in the country that aren't sellable or insurable because of the type of cladding they have. And I have mixed views on that, but this isn't the time or the place to discuss those. But ultimately, if you've got companies that have cut corners deliberately and whatever happened, they got building control or whatever it may be, for whatever reason, there should be penalties for that and people should be made accountable. So they don't seem to be. There should be penalties on the people, the big companies that rip off people, rip off individuals. Because ultimately, I mean, I've got a new build property. I never thought I'd buy one. I did. Husband wanted to. We've been in it 6 years now. So when our house was being built, we were excited about it. We were telling people, and when the inquiry on Grenfell came out, they were one of the first ones on the chopping block. One evening, me and my husband were sitting there and our phones were going mental. Like, what the hell's happened here? And there was something on Panorama, I think. And the name of the company that built our house was on it. And lots of people had heard about it. So they're like, have you heard this? Have you heard that? I walked past that house, my home, that was being built every single week. I've got pictures through the Harris fencing of my house from the day that we bought it or finalised the agreement to the day we moved in, pretty much. Once I saw those fire breaks go in, I wasn't so concerned. This was back in 2018. And so it hadn't long happened. But I knew about construction, I know about fire and all the rest of it. I was making sure they were in because I had a child and we were looking to have others, not twins, but that's another story. But I knew I was going to have a baby in the house at some point. But also it's my house. And I fell out with the contractor because before I purchased it, I had a meeting with the contractor. I had a meeting with the salespeople, a meeting with the site manager. And I said to them, listen, I'm not asking you to do anything different. I know what goes on in people's houses. I know what you do in construction. Just don't do it in my house. I don't want anything special. Just don't cut corners in my house because my name will haunt you. And they cut corners. So, cost them an arm of money. I was fortunate in my situation where things weren't done properly in my house because I had the education. My neighbours were fortunate because I fought for them. I've been in most of the houses in my estate because of that reason, and I supported them. But there is no comeuppance. So unless you know what you're talking about, and you will argue the point, and you will stand your ground, and you will write to the managing director and the legal team, then I would have had loads of things wrong with my house. It would still be wrong with my house. And there are still things in some people's houses down my road, but they're happy with it and that's fine. It's aesthetics, nothing structural. But ultimately, that's not how it should be. And I've heard since then of a number of other people having problems with their properties. There should be penalties around that, and it shouldn't be done. It shouldn't be possible. But again, how that works and how they'll end up going against the bigger boys, I don't know. But ultimately, I do think that the one thing that is shortfall is the penalties on people not doing what they're doing. And there is still corruption in the industry.
Well, that was the Construction Act, or at least the most important parts of it for what we're looking at. Coming up next, we're going to be talking about contracts. This is going to be in depth. Going by what you've said already, there's a lot of information there that people are going to get from it. So I'm looking forward to this one. Michelle, thank you for making such a complex subject so clear and accessible. I'm looking forward to our next chat.
Thank you.
If you found value in today's episode, hit subscribe so you never miss a new release, and share it with someone in the industry who needs to hear it. To learn more, access resources, or find out how Michelle Carr and Construction Alchemy can help you protect your projects, solve problems, and boost your profits, visit constructionalchemy.co.uk. Together, we can change the industry, one project, one company, and one episode at a time. The views and opinions expressed in this podcast are based on the personal experiences of Michelle Carr and her guests. They are for general information only and should not be relied upon as professional or legal advice. Always seek your own independent advice before making decisions. Neither Michelle Carr nor Construction Alchemy accepts liability for any loss, damage, or consequences arising from actions taken based on this podcast. Thank you for listening.